Hello, volunteers. My name is Adonia Simpson, and I direct the Family Defense Program at Americans for Immigrant Justice. I want to thank you for sitting in on this training and thank you for volunteering for our immigration intake clinic. And the purpose of today's training is to run through the intake process and try to answer any questions that you may have. So thanks again, and let's get started. All right, so first of all, when you first meet with a client, it's important to develop a relationship. Make sure that you reinforce that the information and advice that the attorney is going to give is only as good as the information that we receive from the client. So it's really important for people to be as open and honest as possible about their circumstances. If you are not an attorney, please make clear that you are not an attorney and you cannot provide legal advice. Explain that you're going to be sitting down and completing the interview, and then they will have the opportunity to speak to an attorney and have a consultation. Also, another thing, oftentimes we'll see family groups or spouses and children wanting to see and go through the process together. We really encourage people, first of all, to complete a separate intake. No matter how frequently clients think that their cases are exactly the same or that the facts are the same, we really do want to make sure that we're providing very individualized legal assessment on each and every case. We're also wanting to make sure that there's no conflict. We've had cases where there may be instances of domestic violence within the household, and we want to make sure that we're screening for that and making sure to avoid potentially providing advice to both parties and creating a conflict of interest. So if there isn't a conflict, sometimes we may have family members sit together with the attorney because there may be enough overlapping facts that it's easier for the attorneys to provide advice for both. However, the initial intake should be completed for each person individually because everybody does have a different case posture. If there is any sort of domestic violence present, please flag a supervisor before handing the client over to an attorney. The supervisor will determine whether or not the couple or the individuals are able to proceed. Please be very discreet about this. We don't want to do anything that could potentially put somebody at risk. Another thing that we often see a lot of questions about, we may have people coming in that actually want to receive a consultation for a friend or a family member who's not present. As attorneys, we always want to speak to the individual person who needs the advice. No matter how much the person present thinks that they know all the details of their loved one's case, there's a lot of things that people may not know. And in order to provide the best advice possible, we do want to speak to the person directly. So we may be asking the individual to go back, make a phone call, and have the immigrant who needs assistance come in and speak to the attorney at the consultation. We are going to provide some information here a little bit further on about if the individual is detained, what sort of resources are available there. So again, the attorney is only going to be able to provide advice to the extent of the information that's accurately provided. So the devil's in the details. Make sure you're getting all the information possible, and it's really going to facilitate the attorney in providing the advice and counsel. Another big thing is we do right now complete the intake forms via paper. So please write legibly. We actually enter these intake forms into our case management system. So we want to make sure that we're able to clearly read people's names and phone numbers and we're able to do the appropriate conflict checks to make sure that no conflicts exist. And most importantly, we want to be able to read the information so we can follow up as necessary. So when we're going to go in a little bit, we're going to be reviewing the intake form, but make sure that you're asking every question on the intake form. We include them for specific reasons, whether it's demographic reasons, it's going to help with our funding and our grant applications and grant reporting, but also potentially every question does serve a purpose as far as evaluating if somebody is eligible for some sort of immigration relief. After the screening form is completed, the client will have the opportunity to meet with an immigration attorney. So at the event, we'll be providing guidance as far as where people can wait to see the attorney. And it's important to manage expectations. We do a lot of these events and we work with a lot of volunteers and we see a lot of clients. And due to the high volume of intakes, it could take us several weeks to get back in touch. So if somebody needs immediate assistance, it's likely that we may not be able to help, and we're going to be providing referrals so that they can reach out to individuals or attorneys that may be able to assist more quickly. As mentioned earlier, if a client is detained, they should contact Americans for Immigrant Justice's detention hotline. And the number is listed here, 786-454-8554. Going back to the reason that we want to speak directly to the immigrant and to be able to provide advice. So we do have staff that is able to travel to Glades County Jail, Broward Transitional Center, and Chrome to do intakes with clients. So in some situations, you may be working with an interpreter, and some of these things you may already know, but it may not be completely intuitive. Consider the interpreter the vehicle to which you're going to be speaking to the client, or if you are the interpreter, the conduit where the screener is going to be able to speak directly to the client. So here's just some tips of working or interpreting. Make sure that you're really using terminology that the client is using. So if the client says something like, this happened to me, don't say, she said that this happened to her. Make sure that you're speaking in the first question and that you're asking questions directly to the client. You want to make sure that you're really establishing a connection to get as much information as possible. Also keep in mind when working with interpreters to keep the information brief, to allow the interpreter to either interpret what you're saying or to interpret what the client is saying back to you so you don't miss any of the information. And it's always a good idea if you're working with an interpreter to lay the ground rules and how it's going to work and talk to the interpreter about the process, but then also speak to the client. So on the intake form, the first page is all of the biographic and demographic information. So the intake date is going to be the date of the clinic, the intake event that you're at, and the location is going to be the location. So for those of you participating in the First Friday clinics at Florida Immigrant Coalition, you can just put FLIC. Make sure you're writing the client's complete name. Sometimes it's helpful to look at an identification to make sure that you're spelling everything correctly. It's important because we do something called a conflicts check. We want to make sure, we want to see if we've represented this individual before, or if they've sought advice from us before, or also potentially if they pose a conflict, if they were an adverse party to a current or former client. So make sure you get the full and complete name and that it's accurately spelled. Also ask about any other names that they may have used. Sometimes clients may have a maiden name, or they used they had a married name in the past. Other times we have clients that may have presented at the border and provided a different name and date of birth at entry. We need to know all that information. We often do something called a Freedom of Information Act request. That's where we're able to go to the government and get a copy of the immigration file. And we want to make sure that we have all the information, so we're getting all the information that the government has, so we can accurately advise clients about their situation. All right. Sex is how individuals self-identify. Marital status: single, married, divorced, separated, widowed. Please indicate their legal marital status. Oftentimes we have clients that talk about their husband or their wife. However, they're not legally married. It's important because a lot of types of immigration relief, it is dependent on an actual legal marriage. So we want to make sure we know all the facts to properly advise. Race is, again, how the individual self-identifies. We have white, Hispanic, Black, Asian, Native American, Pacific Islander, or other. We often see a lot of clients that are indigenous, so indicate that there. That's really helpful for the attorney when they're trying to figure out if there may be some sort of basis perhaps for asylum. Social Security number, a lot of clients won't have that, and that's okay. If they do, it's not required. It's just a way that we're able to better identify if this person has received services from us before, or if there's a conflict. If the client doesn't feel comfortable providing it, that's okay. Don't push it. Just say does not want to provide. A number or USCIS number. This is the alien identification number. Anytime anyone has had any sort of contact with immigration, whether it's been at the border or they've been in immigration court or they've filed applications or applications have been filed for them, they likely have this 9-digit A number. If it's an older number, it could be 8 numbers and they'll put a 0 in front of it. This is probably the most important number. There's a lot of things attorneys can do with this. We can call an 800 number to see if they're in immigration court proceedings, when they might have court, if they've been ordered removed. It also helps us if we do a Freedom of Information Act request to make sure we get the most accurate information about the individual. So if they have an A number, please indicate it. If they think they have an A number, but they're not sure on what paperwork it is, it could be on their work authorization or on any court paperwork. If they think they have one, but they don't have it with them, note it. And the attorney or our office will do some follow-up to try to get that information. Country of birth is the country in which they're born. Dual citizenship, particularly with clients from, we've been seeing a lot of clients from Venezuela. We see a lot of clients that are actually dual citizens, perhaps born in Venezuela, but also have citizenship maybe in Spain. Extremely important, particularly for individuals that may want to seek asylum. If they want to seek asylum and they are dual citizens, there's an additional level. We actually have to show potential persecution in both countries and not able to seek protection in both countries, which for a lot of clients who may have dual citizenship is pretty difficult. And so filing any sort of petition or asylum application, excuse me, could potentially put them in danger. So we want to make sure that if people are dual citizens, we know about it. Indicate the client's language, any English proficiency. English proficiency is really important for follow-up purposes. Some cases we might try to place with a pro bono attorney, and perhaps the pro bono attorney who's willing to do this case for free doesn't speak Spanish or doesn't speak a second language. So clients that have some level of English proficiency or fluency are sometimes better and easier to place with pro bono attorneys. So indicate if they are able to speak any English and what the proficiency is. Also indicate if the client has any disabilities and what these needs are. If we have to do any follow-up, we want to make sure if there's any need to do any sort of accommodation. All right, so moving on. So this is the second part of page 1, which is the contact information. We're asking about their address. Is it safe or unsafe? And that's really to determine if it's a place that they can regularly receive mail. Some cases, people may not be on the mailbox and they don't really have regular mail delivery or have issues receiving the mail. That would be an unsafe address. In addition, sometimes we see survivors of domestic violence who may feel uncomfortable or may be fearful of receiving any sort of communication from us to their address. And we don't want to do anything that could put somebody in danger. So if it's unsafe, please indicate unsafe, and then a safe address where we can contact people. Next, is the client able to travel to Miami for follow-up? For the FLIC clinics, we'll be here in Miami, but we oftentimes have clients that travel from a really long ways away, and we want to know if they're able to continue doing that. If not, we might have to discuss internally about going to a different location, perhaps further north or out in Southwest Florida to do follow-up if it's a case that we're able to offer representation. Phone numbers are the most important thing. We want to get as many phone numbers as possible, not just their cell. Try to get a contact, an emergency contact, another phone number. So many times we're ready to move forward and offer representation and help somebody on their case, and we can't get in touch with them. The cell phone's disconnected or the voicemail's not set up. So please give us a few phone numbers so we can really make sure that we're able to make contact if necessary. Also, ask about email. You'd be surprised how many of our clients do have email, and it's a fantastic way for us to communicate with people quickly and get information. So ask about an email address and just include it on the line there. Finally, why is the client here today? What sort of assistance are they looking for? This helps the attorney when we sit down to try to determine what sort of advice are we giving. Is it somebody that's looking to naturalize? Are they just looking for status? Are they afraid to return home? Did they get married and they're interested in a spouse petitioning for them? There's a lot of different scenarios. Any sort of additional information that you can get in this regard is really helpful and helps the attorney kind of get in the right mindset as far as what sort of advice they're going to be giving. On the second page, we go into financial eligibility. So for purposes of the legal screening, we don't care about income. We'll provide advice and counsel to anybody. However, if we move forward and want to provide representation to an individual, they do have to be within 200% of the poverty line. Anything over that, and folks can afford to hire a private attorney, and we really do encourage them to do so. So the affidavit of client eligibility is the client's attestation about their general monthly income. The family size is going to be the nuclear family. So mom, dad, and kids. We're not looking at extended family members, cousins, aunts, uncles, siblings, just the nuclear family members and the estimated gross income for the nuclear family. So if mom and dad combined make $400 a month, it'd be 400 times 4, and that would give you your estimated monthly income, and just have the client sign off. We just want to get a general idea that they are within income guidelines in the case that we're able to offer representation. So starting on page 3, we're really getting into the eligibility and exploring all the different family and humanitarian-based types of immigration relief. On occasion, we'll get folks that have questions about employment-based immigration. That's really not our area of expertise. That tends to be private practice, so those folks will likely refer out, but we will continue to screen them for any sort of family or humanitarian relief. So question number 1, what's the immigrant's current status? Do they currently have a visa? Do they have any sort of valid immigration papers, a green card, TPS? TPS stands for temporary protected status, or any other sort of lawful status. If so, what is it? When does it expire? That's really going to help us be able to assess if there's any sort of unlawful presence or what options may be available. It really does change based on what status folks have. Some individuals may have no status, and that's completely fine. You can just write no status. No, question number 2, please list all entries and departures to and from the United States and manner of entry. Extremely important because we see some folks that have entered maybe multiple times without inspection. That's EWI, entered without inspection, and has spent substantial time here without permission. That could mean that they have a permanent bar. So we want to make sure we know all entries and exits. We want to make sure that we have an idea how much unlawful presence somebody has had in the country and when that was, because it really could make the difference between somebody being able to move forward with a family-based petition or potentially facing a permanent bar. And again, our ultimate goal here is to do no harm. We want to make sure that we're providing people with the best advice possible, and we can only do that with all the information. All right, so question 4, do you have and I think we actually missed a question, question 3, question 3 is not on here, but I'm going to tell you what it is because I remember. Question 3 asks about any and all children. So we want to know how many children they have, their ages, location, are they here in the US, are they in a home country, and their status. So some frequent acronyms that we use, just so you know. USC stands for US citizen. That's somebody that's either born here or acquired or derived citizenship or naturalized and became a US citizen. Some individuals may be lawful permanent residents or green card holders, also known as LPRs. Some people may have no status, or maybe they have temporary protected status. When we're asking about children, we're really trying to find out potential qualifying relatives for certain types of waivers or pardons, or perhaps potentially individuals, children that could petition for their parents when they become 21. So knowing the children's status, ages, and location is extremely important. Okay, so moving on to question 4. Do you have a spouse, parent, or sibling who's a US citizen or green card holder? This is exploring other potential family relationships where somebody may be able to petition for the immigrant. So list the relationship. Is it a spouse? Is it a sibling? Where this individual is located at, and what sort of status they have. Is it an LPR, a green card holder, or is it a USC, a United States citizen? The attorney will be able to use that information to explore whether or not any family petitions could be filed, or potentially also a qualifying relative for any sort of waiver or pardon. Questions 5 through 7 are about something called derivative and acquired citizenship. There's individuals, and we run across them every once in a while, who are actually citizens by operation of law. What does that mean? That means that they weren't born here. However, because certain things happened, they acquired citizenship or derived citizenship because these things happened before they turned 18 or perhaps even before they were born. This is a great option. We do encounter it every once in a while, and that just means that folks are able to submit some paperwork and get evidence that they are a citizen, and all these other things may not be as important for them. So question 8, have you ever filed an immigration or has anyone ever filed an application or petition for you, your parents, or your spouse? We want to know if there's any application that's currently pending that we need to follow up on, or maybe there's certain types of immigration relief that are predicated on applications being filed a long time ago, perhaps before April 30th of 2001, which may give folks the opportunity. They may be grandfathered in, which means that it forgives certain things. And it does happen, and we just want to know about any applications that may have been filed and what the status of them was, who filed them, and what was the disposition. Question 9, unfortunately, we may have to remove this question here pretty soon. It's about whether the immigrant or any of the immigrant's family members are currently serving, seeking to enlist, or have previously served in the U.S. Armed Forces. There's a type of immigration benefit called military parole in place, where certain military members were able to get a parole, a special parole for a family member, which would give them the lawful entry that may give them an avenue and down the road to apply to adjust their status and become a resident of the United States. However, here in the last few weeks, we've seen a lot of discussion about this program being ended. We do anticipate there'll be litigation. So right now the question remains, however, this may increasingly become less of an option for some of our community members. All right. So question 10, are you afraid to return to your home country? This is a really difficult question. So many of the people that we talk to, yes, are, excuse me, are afraid to return to their home country. But for asylum, asylum is a really complex relief. It requires the showing of a lot of different elements. So we want to know as many details as possible. Why are they afraid to go home? What would happen to them if they were returned? What happened to them while they were there? Don't stress out too much about this question. The attorneys will definitely do their due diligence and follow up and make sure that all the bases are covered to really assess whether or not asylum may be an option for the individual. But do get an idea as far as why they're afraid to return home. Questions 11 through 13 are about a type of immigration relief called NACARA. It's not as frequent anymore, but we do see it on occasion. We do see people able to apply for the old suspension of deportation and get a green card if these factors apply. So ask, and depending on the answers, the attorney may be able to help. Question 14 has two purposes. Have you or your family ever belonged to or provided support to any organizations, including gangs, political parties, governments, rebel groups, police? Two purposes. First purpose, it could be a social group or a basis for asylum. Maybe they were involved in a political party that was being persecuted and targeted by the government. Alternatively, it could be something that may pose an impediment to relief. It could be an inadmissibility or a bar, particularly gang involvement. To be best able to advise the clients about what sort of obstacles or hurdles they may face, we need to know any and all involvement in any sort of groups, political parties, organizations, gangs, government. Note it, and the attorney can follow up accordingly. We may not see a lot of young people, but if we do, if the person is under 18 years of old, they're under 18 years of age, there's a type of immigration relief called special immigrant juvenile status. And if there's been abuse, abandonment, or neglect by one or both parents, and certain things happen, including a finding by a state family or dependency court judge, that individual may have an option to apply for eventually for a green card, for a special immigrant juvenile visa and a green card. So if they're under 18, explore the situation with the parents. Was there any abandonment? Was there any neglect? Explicit abuse? Note that, and the attorney can follow up to see if special immigrant juvenile status may be one avenue for the young person. So we're continuing on with other types of humanitarian relief. Question 16 asks if you or your spouse or your child have ever been a victim of a crime. Specifically, the attorneys are going to be interested about any victimization here in the United States. There's a type of visa called a U visa, which is for victims of certain qualifying crimes, which tend to be a little bit more serious. However, to qualify for this U visa, you have to have cooperated with law enforcement with the investigation or prosecution of the case. So first of all, we want to know when and where did this crime occur? Did they report it? Did they cooperate? What happened? And also, if they know who the perpetrator was, we do want to know their name, status, and date of birth, particularly in situations involving domestic violence. We want to make sure that we're running a conflict check to make sure that we're not potentially providing representation to the other party. So make sure to get these details, and then the attorney may, depending on the responses, follow up with law enforcement to see about getting a certification to proceed with the U visa. Question 17 it's a tricky question. It's getting towards a type of relief called a T visa for survivors of human trafficking. And trafficking, as you may know, is not just sex trafficking, it's also labor trafficking. So a lot of the questions, this is a hard question to ask, and most people, because a lot of people won't identify as being trafficked. So ask questions about if they were promised a job here, if there was any force, fraud, or coercion in their workplace, if they had their earnings withheld, were they ever physically or sexually abused or made to do things against their will? Had they had their documents taken away? If so, write the details and the attorney can delve in. Be careful. Sometimes these subjects are sensitive, so trust your gut. If you feel like maybe it's better to wait, make note for the attorney to do additional follow-up if you feel like there might be something there, but the client maybe doesn't feel comfortable talking about it at this time. So question 18, have you, your spouse, your children, you or your children ever suffered any sort of mental, physical, or emotional abuse by a U.S. citizen or lawful permanent resident? There's a type of immigration relief called VAWA, the Violence Against Women Act, which is available to men and women alike, but it provides a way for individuals to self-petition or to seek relief without their abusive partner who has status. Oftentimes in these sort of relationships where the abuser is a green card holder or a US citizen, there's an imbalance of power. And what VAWA did was it allows certain remedies and avenues for individuals in these circumstances to self-petition, to do the paperwork themselves and not be dependent on this individual. So ask if there's any sort of mental or physical abuse, and if this individual was a US citizen or lawful permanent resident. Question 19, does a USC, US citizen, or LPR, lawful permanent resident's parent, spouse, child have any emotional or physical disabilities? And 9 times out of 10, people are really quick to say, nope, everyone's great. I usually like to follow this up by saying, immigration oftentimes doesn't care about the condition of immigrants. Waivers and pardons, and a lot of immigration relief is really predicated on some sort of hardship or difficulty that would be suffered by a qualifying family member, which is usually a spouse or parent and sometimes a child. So if there's any sort of learning disabilities or things that would make it difficult for an individual to return to a home country, note that. The attorneys can do follow-up, but if there's anything there, it's going to be critically important for determining if there may be a waiver available. All right. Question 20, have you ever consulted with an immigration attorney or notario? If somebody does, we oftentimes see folks that have an attorney and are wanting a second opinion, and that we can provide a second opinion. 9 times out of 10, the attorney that they're working with is doing a great job. It's a matter of really explaining that the immigration system, particularly in the last 2 years, has become a lot more complicated, and there's a lot more backlogs. Processing times have skyrocketed, and even with having representation, it's hard to, you're not going to see immediate results. However, sometimes the bigger issue are notarios. Unfortunately, right now, with the amount of misinformation in the community and fear, there's a lot of bad actors out there that are preying on this and making promises We see a lot of notarios filling out paperwork for folks that are not eligible for the benefits. And as you can imagine, you know, best case scenario, folks may be losing their money, but worst case scenario, they could be put into immigration proceedings or even potentially deported. So it's important for us to kind of track who these individuals are. So if they've gone to a notario, you know, note who it was and when it was. And earlier on the previous page, you probably already indicated whether or not any applications or petitions have been filed. So that's really important. So as mentioned, we can provide a second opinion, but usually if people have an attorney, things are just, it takes time. And we really encourage people to go back and speak to their attorney and get the answers that they're seeking, but we will provide a second opinion. Questions 22 and 23 are all about any sort of contact with immigration. You know, you can ask the question, have you ever been ordered deported, or have you ever been in removal proceedings? But a lot of the times clients are going to say no. If on the first page of the screening form, they told you that they encountered immigration at the border, that they were stopped, it's very likely that they may have a removal order. We see a lot of folks that encountered immigration when entering. They were issued a notice to appear, but didn't realize that they actually had to go to court and may have a removal order in absentia. That's definitely a circumstance where we'd want to do a Freedom of Information Act request, because we'd want to see exactly what happened and when, because we don't want to file paperwork for somebody that may have an order of removal. We may have to actually file a motion to reopen before we proceed. So question 22 is a little tricky because people may say no when the answer in fact is yes, and it's just a matter of them, the individual, not understanding or realizing that it does apply to them. Any other contact with ICE or Border Patrol we want to know about. If they provide any information about circumstances or conditions that's noteworthy, please include it. You know, we are looking for instances where maybe there's been some sort of mistreatment. There may be options in their immigration case given that, or for a complaint. So if they mention it, please note it. It's always better to have more information rather than less. So if you're in doubt, I think the rule of thumb is write it down, and the attorney can do what's necessary to follow up and drill down to see if anything applies or not. So the remaining questions are all about interactions with law enforcement. We really want to know if anyone's ever been put in handcuffs, detained, taken to jail, not just here in the United States, but also abroad. A lot of times clients will just tell you, oh, it wasn't a really big deal, it got dismissed, I had an attorney clean it off my case, so it doesn't matter, or off my record, so it doesn't matter. Everything really does matter. So many of the types of immigration relief are discretionary, which means that the immigration judge or the adjudicating officer is going to be looking at an immigrant's entire life here. And even if cases were dismissed, they could still maybe take into consideration various arrests and ask questions about the circumstances of what happened. So we need to know all the information just to be able to better prepare and make sure that, you know, there's no surprises and that we don't file an application for somebody who may not be eligible. So the intake form has lots of places to put notes. Feel free to use those. Anything that struck you that you think the attorney should know, use the notes section. As I mentioned earlier, if you're not sure if something's relevant or not, go ahead and make note of it, and the attorney can dive into it. And you know, you'd be surprised how much information is actually really important. As mentioned at the very beginning of this training, every single one of these questions has a purpose to really assess whether or not somebody may have options or if they may be barred from options. So make sure you're getting all the responses, and then before you pass it off to the attorney. So you'll see that there's a place for a screener name and signature. So if you're a non-attorney, make sure that you write your name there and you sign. And that's just in case we have any follow-up questions, or maybe if we don't quite understand something and we want to reach out to you just to get clarification. So make sure to include your name and signature there. And then for any attorneys that I may have on the training, you know, your job as the attorney is to provide the advice and counsel. I like to review the intake and just double check on certain questions. A lot of times I'll say, so just to make sure you've never been a victim of a crime. I also use these opportunities to educate people about their rights, tell them something along the lines, I hope you never are, but should you be a victim, really important to cooperate with law enforcement. Sometimes there's certain avenues there. If there's anything of interest on the intake following up, for the attorneys, if they've had our policy recently is if there's ever been any interaction with immigration, we want to do a FOIA, a Freedom of Information Act request. And that's where we're able to do it with USCIS, with Customs and Border Protection, with the Executive Office of Immigration Review. So if we have attorney volunteers at the event and you think a FOIA is merited, flag the coordinator and we can get that completed. And just put the client at ease that results will be sent to AI Justice. We won't be providing immigration with the client's address. They will be coming to our office. Our staff will review them and provide any sort of assessment to the client, and then also provide the FOIA to the client for their own records. It's really important that people actually have a full and clear understanding of their immigration history. Attorneys should answer any immigration-related questions that the client may have, address any issues as far as should somebody be detained, what happens, should somebody be put in removal proceedings, if that would change their options, reinforce the rights that people have, and tailor that to the individual client. Also, it's very important for the attorneys, please note clearly any advice that you provided. If unfortunately at this time there's just no relief for the immigrant, state that you told them that. If you think that there's something that we need to follow up on back at our office, if we need to review some criminal documents that perhaps the individual didn't have with them, or we need to look at something to see if they might be eligible for 245I relief, note that so we can make sure to follow up appropriately. However, I do want to manage expectations. We have a very small staff that works extremely hard and they have a lot of cases. So our ability to take on new cases are limited. The advice that's being provided may be that they need to hire private counsel upon follow-up. There's a lot of cases we just don't particularly have the capacity to take. So just make sure that you're managing clients' expectations. There is no guarantee of representation. If somebody has court in the next coming weeks, it is extremely unlikely that we would be able to go to court with them. We may be able to provide them with a letter that they can take and show the judge to have evidence that they've been actively trying to hire an attorney. But turnaround time just between putting intakes into our system and doing the necessary follow-up, it's likely that we will not be able to assist if there's a hearing date extremely soon or a check-in with Miramar. So I think that's all the advice that we have for the attorneys and the folks doing the intake. I just want to re-emphasize that managing expectations is so important. It can take, up to 4 to 6 weeks. We're not taking that long, but do give them the higher end of things. We don't want to field a bunch of phone calls on Monday wondering if we're going to take the case or not. So manage expectations. There's no guarantee for representation. However, everybody that does attend a clinic will receive Know Your Rights information, will receive both nonprofit and private referral information, will receive information about fraud. So we want to make sure that people are walking away with the best idea possible about what their options are and resources if necessary. And again, really stress that people do have the ability. We have a lot of fantastic private attorneys through the American Immigration Lawyers Association. A lot of the attorneys that frequently volunteer at our clinics are included on our referral sheets that we do provide. So if people are able, and especially if the case is time sensitive, they should really consider consulting with a private attorney. So some folks may be asked to work on exit depending on the event. What's important about the exit station is just really verifying that everything has been completed, that all the demographic information is completed and that it's legible. We want to make sure that we're doing this before the client leaves, so we make sure to grab them before they leave. Make sure that they sign the client affidavit regarding eligibility about their income, that all the questions are answered, that the attorney wrote the notes. We want to grab the attorney while it's still fresh in their mind to put any notes that may be missing, that the attorney signed off on the limited representation agreement, and that the client did as well. At the end of the intake, there is a limited representation agreement that's really stressing that the purpose of the clinic is to provide advice and counsel, that there's no representation beyond the event that day unless AI Justice follows up and offers representation. So the volunteer that's been meeting with the individual is not their representative. That everything, also it's important to stress that everything is confidential. We oftentimes get questions from people asking what's going to happen with their intake form. That goes back to our office. It's not shared with anybody. It's not given to immigration. We do everything possible to protect our clients. Just make sure that the client also signed the limited representation agreement. And then if applicable, if the attorney identified that FOIA's Freedom of Information Act requests were necessary, that the FOIA's and the FOIA retainer were signed. Just to let you know, the FOIA retainer is just to re-emphasize to the client that we're doing a FOIA to get a copy of their file, that we'll be reviewing it, and that we'll send them the results when received. So if any of those things are not completed, just make sure to grab the client to complete anything that's missing, or the expert attorney to provide the advice. As mentioned earlier, every client should be getting a list of private and nonprofit referrals. We also see a lot of folks that mention that they have family members that would be interested, so feel free to pass out clinic information about upcoming clinics. We may see some folks that have interest in naturalization. The Florida Immigrant Coalition has lots of events coming up, so feel free to share any available flyers with the individual about that. Give out Know Your Rights and Notario information. And if the client, unless the client was explicitly told by the expert attorney that there was no relief at this time, make sure to let clients know that it could take a few weeks for the organization to follow up. And at this time, there's no decision about representation. So that was the lowdown on volunteering at a screening clinic. I hope it was helpful.